Hi, everyone. We're going to get started today. Here's our presenter, Lillian Shapiro of HR 360.
Thanks very much, Frank. And hello and welcome to our training session today on sexual harassment prevention. We've got a lot of great information on guidelines, tips, and explanations on how to really make sure, as well as we all hope, that all our employers and employees will do everything they can to prevent sexual harassment in the workplace. Now, this is a very, very significant issue and a costly problem in today's business environment. There's no question about it. Our goal today is to provide you with a greater understanding of sexual harassment, including prohibited behaviors, effective reporting procedures, and the importance of prevention. And I want everybody to know out there that this webinar was developed by the staff attorneys at HR 360. And so let's continue on, Frank. Thank you. In this webinar, we're going to basically cover an overview of sexual harassment, including how it is defined under federal law. And then we'll move on to explain the two types of sexual harassment. One is quid pro quo, and the other is the hostile work environment, and describe some of the different circumstances in which sexual harassment can occur. We'll also address how to report and investigate sexual harassment. And finally, we'll end with how to keep sexual harassment out of your workplace by taking effective steps to prevent it. So let's continue on. Thank you. Now, sexual harassment is illegal under Title VII of the Civil Rights Act of 1964. And basically, it applies to nearly every employer who has 15 or more employees. Now, most states also have similar laws prohibiting sexual harassment, and some state laws apply to employers with fewer than 15 employees. In addition to violating the law, sexual harassment creates a negative environment in the workplace, and that can lead to low morale, loss of productivity, and poor employee retention. So it really does quite a bit of damage up and down the line, and it's something we all have to be very focused on. So let's continue on, Frank. Thank you. Now we're going to define sexual harassment. People are often confused about the difference between harmless joking and sexual harassment. The federal government defines sexual harassment to include unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. Although the law doesn't prohibit simple teasing or offhand comments or an isolated incident that could not necessarily be very serious, harassment is illegal when it is used as a basis for employment decisions or when it is so frequent or severe that it creates a hostile or offensive work environment. Now we're going to explain the definition of sexual harassment in more detail with the next slide. So let's move on, Frank. Thanks. Now, two categories of sexual harassment. The first one we had talked about and mentioned a moment ago, quid pro quo. And what that means is this for that. And that actually entails submission to or rejection of unwelcome sexual conduct, and when it is used as a basis for employment decisions. And what that means is, what's an employment decision? It could be hiring, job responsibilities, firing, promotion, demotion. So I think you get the idea that it's all aspects of the employee life cycle, if you will. And so it's something that you have to be very, very wary of. It cannot impact or affect any of these areas. And if there is a sexual misconduct going on and then it affects all of these areas, you know you're in quid pro quo, and it is absolutely, absolutely not allowed. So let's continue on to the second aspect of or category of sexual harassment, and that's called the hostile work environment. This second type of sexual harassment occurs when the unwelcome conduct is so frequent or severe that it creates an intimidating, hostile, or offensive work environment. This could include sexually explicit jokes, photographs, conversations, or emails. A single unwelcomed act of harassment may be sufficiently severe that it creates an unlawful, hostile work environment. However, to be unlawful, the harassment must be both subjectively and objectively offensive. So when we're looking at this, it really has to be something that clearly can be seen as an harassing event or something that's either intimidating or all the types of activities that we talked about. But there has to be a level of objectivity also applied to it to really fully comprehend whether this is a hostile work environment. So in case you might be asking yourself out there, well, gee, I'm not sure, or, could this teasing aspect of something be considered a hostile work environment and so forth? I think the best road to take or path to take is an environment with every employee has mutual respect for each other. When both the employer and all the employees, the entire workforce, really kind of follow that one basic concept of mutual respect for the fellow worker, a lot of this can be prevented. Although we're going to go into a lot more detail now, it's something that I want all of us to really think about. Respectfulness, kindness, doing the right thing. Those are your basic types of behaviors that you want modeled. And actually, you want that kind of philosophy out there. But in addition to that, we have to know what the actual laws about sexual harassment are about and how to prevent them. So let's continue on. Thank you. So we're further defining sexual harassment. Sexual harassment can be overt and entail obvious physical gestures. Alternatively, sexual harassment can be more subtle and consist of innuendo and comments. Also, it's important to note that sexual harassment need not be specifically sexual in nature, but may also include offensive remarks about a person's gender. For example, making an offensive comment about women in general. So yes, there's ones that are stated that are most obvious, but even the more subtle ones, as the example I just gave was about, you really have to think about that in terms of, when the training is going on and when explaining all this to the workforce, that it really is the overt and it's more the subtle also. All of it should never be allowed. And again, go back to the philosophy of respect for our fellow workers. So let's continue on. Now, federal law does not prohibit simple teasing, offhand comments, or isolated incidents that are not very serious. So I guess, again, folks might be saying, well, can I have a laundry list of those? And I'm really not going to give those to you today, except for the fact it should pass the test that I've talked about, that, if there's something that even seems vaguely in some fashion not respectful or unkind, it doesn't belong in the workplace. It's just that simple. It doesn't belong in the workplace. So let's continue on. Thanks. Now we're going to get into some examples here of a hostile work environment. So let's take a look at a couple of these, just right now for the next few minutes. So example one involves Mary, who is the first woman hired into her company's freight department. She's given a desk at the receiving dock amongst four of her male colleagues. One of them has sexually explicit pictures posted on the wall of their shared cubicle. This makes Mary uncomfortable and sets a tone that she feels is inappropriate for the workplace. She mentions this, but the colleague refuses to remove the pictures, and the department boss ignores the whole situation. Mary is in the midst of a hostile work environment. Her colleague has displayed suggestive pictures that make her feel uncomfortable and is refusing to remove them. Furthermore, Mary's boss won't do anything to stop the behavior. In example two, Paul has a reputation as the office jokester. He's a comedian. He regularly sends funny emails via the company intranet to a list of his colleagues. In recent weeks, he has begun forwarding jokes of a sexual nature. These communications make Jennifer, a worker who reports to Paul, uncomfortable. When she says something, Paul tells her, you have to lighten up and be part of the team. She's afraid to pursue the subject further because Paul is her boss. Jennifer is being subjected to a hostile work environment. Being forced to receive Paul's off-color material is unacceptable. Furthermore, it's persistent, even though she has requested that Paul stop. And he continues to send the emails. In addition, because Paul is her boss, addressing the problem feels intimidating. So that gives you a couple of examples of what hostile work environment means and feels, and something to really tune into. So let's go on to another example. Now let's consider a workplace exchange between coworkers. Brad sees Lisa in the hall and tells her she looks nice. Lisa says thank you, and Brad adds, The blue in your dress really compliments your eyes. Lisa isn't sure what to say. Eventually she says, thank you, and walks away. Is this sexual harassment? No, it's not. Simply complimenting someone or making an isolated remark about his or her appearance is not necessarily considered harassment. If the same remarks were repeated day after day, however, or if they become more suggestive, they may rise to the level of harassment. The speaker's gestures and even tone of voice might make a difference as well. So as you can see, it's not necessarily a simple black and white area. There are gray areas here. So it's something absolutely that employees on every level, managers, supervisors, employees, must tune into when they're thinking about complimenting or how they want to frame or say something. It's sometimes in the eyes of the beholder and sometimes how that person feels when they're being complimented. It's still very, very important, even in a way, you know, when it's not as, when it's more subtle, that's when sometimes the gray areas could get someone into trouble. So it's important to really think about the kind of compliments or types of conversations one is having with a fellow employee. So let's continue on. Thanks. So our examples showed workers of opposite genders, but there are many and varied circumstances under which sexual harassment can occur. The victim or the harasser can be of either gender, and the two parties are not necessarily opposite sex. It could be the same. Additionally, the harasser can be a colleague, a supervisor, an agent of the employer, a supervisor in another area, or a non-employee, such as a client or customer. So really, there's a broad range here of individuals involved, and everybody has to just essentially keep in mind all of these very, very important guidelines related to sexual harassment, wherever you are on the spectrum, employee, client, consultant, whoever it may be who is interacting with the workforce. All of it's very important to remember about sexual harassment prevention and sexual harassment guidelines. So let's continue on. Now, there are some points to keep in mind here. First, sexual harassment can happen when the behavior creates a hostile work environment for people other than the intended victim. So what do I mean by that? For instance, let's say a man, we'll call him Rob, works in the company mailroom, and his coworker has posted a pinup calendar on the wall in the communal area displaying photos of scantily clad women. Rob is made uncomfortable by the calendar and asks his coworker to take it down, but the coworker refuses. This could be a case of hostile work environment, even though the coworker wasn't trying to harass Rob, and Rob's a man. It means that something that goes up that a whole other bunch of employees can see and potentially might be offended by it, that could also be a hostile work environment. Also, the victim does not have to suffer economic injury for sexual harassment to have taken place. However, conduct must be unwelcome in order to constitute sexual harassment. As a matter of course, it's always safest to assume any potentially questionable conduct is unwelcome, since those who feel harassed may not share their feelings openly. So again, it just goes back to what we've been saying. You know, if we're not sure, just remember there are sensitivities all around. People have different perceptions of what is being said. So if the underlying message of all this is to be careful about what is said, to be respectful, to be sensitive about all the folks in the work environment, those are guidelines that will always serve an employer and his or her employees very, very well. But again, there are a lot of gray areas, and you might think, hey, I'm not trying to harass that person. I've not done anything. But yet something that was posted or stated that that particular worker was exposed to, that in essence could become a hostile work environment. So let's continue on. Now, as another example, imagine a female supervisor giving a shoulder massage to a male employee who works for her. When the employee asks the supervisor to stop, she continues saying, gee, when I hired you, I thought you were going to be a team player. This behavior constitutes sexual harassment. The supervisor engaged in unwelcome physical contact with her employee. In addition, the supervisor's statement that the employee is not a team player implies that the employee's success on the job is conditioned on his accepting the supervisor's advances, a quid pro quo case of sexual harassment. So it may not be what one might imagine typically in terms of a quid pro quo case, but this is a perfect example of what should absolutely not be done whatsoever in the work environment, or frankly anywhere where it's unwanted advances, but particularly this is an example of quid pro quo in the workplace of sexual harassment. So let's continue on. Now we're going to talk about sexual harassment and technology. And what do I mean by that? Sexual harassment can occur through text messages, email, social media, cell phone screen displays. Through technology and the way, I guess, companies and individuals just essentially live and work in their daily life, so much of what we do, our activities are centered, we're tethered, let's face it, to phones, iPads, social media. So it's important to remember the sexual harassment prevention guidelines that really transcend not just the physical workplace, but all the areas that an employee could potentially be involved in, where they could be subjected to, or they could be the ones subjecting to others to some form of sexual harassment. And by the way, social media, texting, it's very powerful. It's a voice of this generation, and it's very, very important to remember because of that voice and the ability to quickly, and this is something actually that is important to note. You know, many times you might see either in a Twitter account or maybe in texting, the way the technology works right now is you don't necessarily think about what you're going to say or do. You just kind of do it. And so there's not a lot of forethought. Keeping that in mind and knowing about the sexual harassment prevention guidelines, it's so important to remember that even though, you know, the minute you think of something, it could be a text, it's important to take a breath, take a second, take a minute to think about what you're texting or emailing or any of the aspects related to social media, because once it's out there, it is out there. And you might try deleting and doing all that stuff, but the event happened. And so instead of worrying about, gee, I just went too quickly and I shouldn't have said that, take that breath, take that minute or two, and think based on these guidelines, is this an appropriate thing to text or email about or post on social media or not? Those 2 minutes can be a lifetime if properly vetting these types of different communications. So let's continue on. Thank you. Now, in addition to happening through technology, sexual harassment can also take place in person, but outside the physical boundaries of the workplace. Behavior that occurs at off-site work functions, on business travel, at client offices or events can be considered sexual harassment. So again, we want you to just think outside of the box here. It's not just in the actual physical confines of the workplace, but all the different types of locations and areas where employees and workers or employees and consultants or employees who are with clients, all of it can happen. And it doesn't have to happen, again, in the physical environment of the actual workplace. So it's important to remember that you take those sexual harassment prevention guidelines in your heart and in the head, so you know it intellectually and you know it deep inside, so that you know, the employee knows how to make sure to prevent sexual harassment regardless of where they are. So let's continue on, Frank. Thank you. Now we're going to take basically a moment or two to talk about office romances. Now, it's essential for all affected parties to maintain professional decorum and avoid any behavior or conduct that may be considered sexual harassment. Simply asking another employee out on a date is not sexual harassment as long as the individual asking can take no for an answer and not persist with unwelcome requests. Nor is dating a colleague considered sexual harassment as long as the relationship is consensual and welcome. Remember, a sexual harassment claim may be based on behavior that either results in a hostile work environment and or results in a tangible employment action, such as firing, promotion, demotion, based on submitting to or refusing unwelcome sexual advances. So what's important to remember here is that asking someone out on a date, okay, fine, yes or no, that ends the conversation. But if it persists, and if there is some kind of a quid pro quo or whether it's a promotion or something going on where the person's being harassed or the person's being asked out any number of times intensely, and somehow there is a sense that a promotion or something positive in the work environment will happen if they go out with the person asking, that's not good. Not allowed. Should not happen. So the thing about office romances are it could be a slippery slope. It could be that at the beginning everything's fine, and then it continues on, and then somehow or another starts to transcend into a gray area that could absolutely lead to a claim of sexual harassment. So it's very, very important to remember this if there is some kind of a dating scenario or asking someone out on a date is happening. These types of guidelines especially must be complied with in areas like that because, like I said, it could descend into something that would be absolutely not allowed. So let's go on. Thanks. So how do we communicate the sexual harassment policy, the guidelines? So let's talk about what a policy should include. First and foremost, it should be written. So let's understand that. Just having something that's said verbally, not the same thing as a written policy. And it should include, at a minimum, a clear explanation of prohibited conduct. There should also be an assurance that employees who make complaints of harassment or provide information related to such complaints will be protected against retaliation. And we're going to cover more of that shortly. A clearly described complaint process that provides accessible avenues for reporting harassment. Provisions for a prompt, thorough, and impartial investigation. Assurance that the employer will protect the confidentiality of harassment complaints to the extent possible, and I will talk more about that as well in this presentation. And assurance that the employer will take immediate and appropriate corrective action when it determines that harassment has occurred. So those really are your big guidelines. So let's continue on. This is a very, very important point I want to just spend a minute or two on. Now, the sexual harassment policy, including complaint procedures, must conform with state law requirements. So it's very, very important when you are putting your policy together to not only look at the federal requirements, which is what we've been talking about, but many, many states have passed their own sexual harassment guidelines, and they must be included. It's very, very important in the policy. So again, putting it together, obviously federal, but please make sure you check your state sexual harassment guidelines. I can't emphasize that enough. So let's continue on. How do we communicate the policy? Employers should provide every employee with a copy of the policy and complaint procedure and redistribute them periodically. And what do we mean by redistributing? It means that you decide, but once a year, twice a year, reminders, refreshers on what this is all about. Because you know what? You distribute a policy, kind of people forget at a certain point, life goes on, people are busy at work, but it should be there should be a reminder at least a couple of times a year of what this is all about, because that's how people are. It's human nature. And having that scheduled, like I said, 1-2 times a year, that makes a big difference. And additionally, you want to write a policy in a way that it'll be understood by employees. Again, you want to make sure that, the wording, the way it's described, is easily understood by all. You can post the policy and complaint procedures in central locations and incorporate them in employee handbooks if you have them. If not, you can certainly distribute the policy by itself. Now, you also want to provide training. There are requirements out there to all employees that, particularly, first of all, it's generally a rule of thumb, you should be doing it. For training for all employees, but there are some states, including California, Connecticut, and Maine, require training for certain employees. So those are the states that absolutely require the training, but really, when you think about it, it is so important for every single employee to have sexual harassment prevention training. It's just that simple. Now, let's move on to the next slide. We're going to talk a little bit more about training. Now, options for sexual harassment prevention training include on-site training by a professional expert in sexual harassment prevention. There are lots and lots of professionals out there. And then there's something else out there that's all tech, all online. They're called LMS systems, or learning management systems, which provide online sexual harassment prevention training, as well as other courses that help employees, supervisors, and managers stay compliant. Now, LMS systems typically track employee progress on completion of courses. It's also, because it's online, it's available 24/7 when somebody has the time to do it on laptops, tablets, and smartphones. HR 360 has an excellent LMS system. It's economical. All the materials or content are developed by our team of attorneys. Please let us know if you'd like to learn a little bit more about it. But regardless, the learning management systems out there, that's such a practical and smart way to get all of this training done. It's just, it's new age. This is what everyone's doing now. And it really is quite an excellent investment for all the employers out there to make sure their employees will be compliant with all the sexual harassment prevention guidelines. So let's continue on. Thank you. So we're going to talk about reporting sexual harassment. Now, as a first step, it's helpful for the victim to directly address the harasser and clearly inform him or her that the conduct is unwelcome and must stop. This applies both to sexual advances and behavior that contributes to a hostile work environment. Now, it's important to note that a victim is not obligated to do so before pursuing other remedies. There may be circumstances such as where a supervisor is engaging in the unwelcome conduct in which the victim may fear repercussions from complaining about the harassment. If the unwelcome conduct continues, the victim should immediately report the alleged sexual harassment using the employer's complaint and grievance system. So remember, there has to be some mechanism inside your company that allows somebody who feels they've been harassed to report the alleged incident and to be able to know that there is recourse, and they essentially know who and what and why, where to turn in the event something like this has happened. So let's continue on. Now, upon receiving a complaint involving an allegation of sexual harassment, supervisors should immediately notify an HR representative or somebody designated at the company who would be in charge of this area. Not everybody, and some of the smaller companies do not have full-time HR folks on staff, but there has to be somebody objective who's not involved in the chain of command at all, who immediate chain of command, who really is the go-to person for that particular company, whatever the size, to take care of such a situation. A supervisor should also immediately notify an HR representative if he or she has any reason to believe or suspect that sexual harassment may be occurring. So let's talk about our next item, our next slide, which is talking about the confidentiality of the complaints. Now, employees will sometimes ask a supervisor to keep a complaint of sexual harassment confidential, or request that no action be taken regarding the complaint. While you can assure an employee reporting harassment that the situation will be kept confidential to the greatest extent possible, it's important for the employee to understand that total confidentiality cannot be guaranteed. You should explain that the company takes harassment allegations very seriously, and the company policy requires that such situations be reported and investigated as appropriate. So you can't always necessarily, I guess, guarantee complete confidentiality, but to the extent possible, that's what we're basically saying right now. So let's continue on. And this is a very important area. I'm talking about retaliation. It's essential for any person who believes that he or she is a victim of sexual harassment to know there will be no retaliation for reporting allegations. Retaliation is against the law, and in fact, if reporting sexual harassment is done in good faith, the accuser is protected from retaliation, even if the charges are determined to be unfounded. So very, very important, because it's frightening that somebody might be very fearful and they're afraid there's going to be retaliation and thus will not be reporting. It's against the law. It's just that simple. It's illegal to retaliate for an employee filing a discrimination charge or for testifying or participating in an investigation proceeding or litigation under Title VII. So it's important to note that. Now, what are some of the examples, going on to the next slide, what are some of the examples of illegal retaliation? Termination, demotion, reduction in pay, denial of a promotion, threats, unjustified negative performance evaluations, increased surveillance. So we can see there's a broad range of possible illegal retaliations. And so this is important to absolutely communicate that the person who's been allegedly harassed does have recourse and must be protected against illegal retaliation. All right, let's continue on. So we're just going to take a moment again to just talk about the fact that the reporting policy must conform with state law requirements. You notice about every 3 or 4 slides, I'll be talking about that because federal and state just simply go hand in hand. Remember, your policy on reporting sexual harassment complaints, like all parts of your sexual harassment policy, must conform with any applicable state law requirements. You can go to the state law site. If you have an HR library, there's quite a bit of information covered on that as well, but in the state law section. But the bottom line is got to do some homework and make sure that the state laws basically that are out there have to be reviewed in addition to all those federal guidelines we've just been talking about, and making sure that you are conversant, you know about it, and you're following those guidelines. So let's continue on. We're talking now about still sexual harassment investigations, and we're just going to kind of dig into it a little bit. After HR is notified of an allegation or potential incident of sexual harassment, any further investigation should be conducted only under the direction of the HR person or department or the designated person in that particular company. It's also essential that the investigation process be carried out in compliance with, of course, the company policy and applicable law. For an example, an employee who is represented by a labor union can have union representative at an investigation meeting if the employee reasonably believes the meeting may result in disciplinary action. So cases are different, obviously, if unions are involved, but everybody involved has to really know the federal and state guidelines and, of course, of their union contracts and so forth. Once the allegation is reported, it should promptly be determined whether an investigation is warranted. For example, if the alleged harasser doesn't deny the accusation, there would be no need to interview witnesses. The employer could immediately move forward with determining appropriate corrective action. If a fact-finding investigation is necessary, it should be launched immediately. The amount of time that it will take to complete the investigation will depend on the particular circumstances. If, for example, multiple individuals were allegedly harassed, then it will take longer to interview the parties and witnesses. So again, each case is different and has to be determined based on how many people are involved and so forth. So every case has to be determined separately. Now we're going to talk about in our next slide, intermediate measures to preclude further harassment may be necessary. And what do we mean by that? Now, at the same time, it should be determined whether any intermediate measures are required to insulate or protect the alleged victim from further harassment. Now, examples of such measures are making schedule changes so as to avoid contact between the parties, transferring the alleged harasser to a different department, or placing the alleged harasser on non-disciplinary leave with pay pending the conclusion of the investigation. The complainant, the person who is complaining here, should not be involuntarily transferred or otherwise burdened, since such measures could constitute unlawful retaliation. So even when you're trying to do the right thing here about protecting the person who made the complaint and so forth, you have to just be very careful and very analytical. Here are some of the examples that we just talked about on the slide, but by the same token, you have to make sure that the person who made the complaint and somehow or another doesn't feel like they're being burdened and suddenly they're made to move to a different department or an area that they don't really have that much experience in, where they don't feel that it's beneficial to their career. I mean, that could constitute unlawful retaliation. So even if somebody thinks that they're doing the right thing, you really have to look at all aspects of every step being taken here to make sure the right thing is being done and not to fall into a trap like that unlawful retaliation, even if the employer is thinking, oh, gee, I'm helping them out by moving them, not if it suddenly is damaging to the complainant's career or puts a burden on them that was unfair. So let's continue on. Still conducting the investigation. The employer should ensure that the individual who conducts the investigation can objectively gather and consider the relevant facts. The alleged harasser should not have supervisory authority over the investigator and should not have any direct or indirect control over the investigation. This is so critical. I mean, it's very clear and very straightforward what I'm saying, but it's sometimes it happens, you fall into a trap, and somehow or another the harasser or alleged harasser is a supervisor in this situation, and then people are trying to figure out what to do. The rules are straightforward. They can't be any clearer than what they are right here as I'm speaking to you now. So again, you have to really, investigators should be independent and objective. The alleged harasser should not have authority over the investigator or the investigation, and the investigator should have skills required for interviewing witnesses and evaluating credibility. So there has to be a sense of expertise, experience, sensitivity, all of it, while understanding all the guidelines provided by both federal and state. So there's a lot going on here, but it's important to get that investigation done correctly and within the framework of the law. So let's continue on. So we're going to talk about basic investigation steps. The first one is interviewing the complainant or the person who complained. So what are we saying here exactly? What does the complainant say happened? What does he or she name the actual harasser? Where and when did the harassment take place? How did the complainant react? Were there witnesses? Was it an isolated incident? Or is the alleged harassment ongoing, happening to that very day? Has the complainant spoken to anyone else about the alleged harassment? So you can see from the type of interview questions for the complainant, there is a series. There is a way that this flows. So the person doing the interviewing has to have everything organized and be able to capture all of the answers in a professional way that really allows a full scope of what's going on during that interview. So it can't be just, not recommended, one or two quick questions. It should be organized and really thought through very, very carefully. So let's continue on. Second, interview the alleged harasser. What is the individual's response to the allegations? Are there any other parties that may have relevant information? It's important to stay objective and do not assume anything. So this is a thread that goes through the entire investigation process, which is objectivity. In other words, someone might hear something that actually makes somebody very upset. The interviewer could be upset by what they're hearing, but their job is to make sure they ask the right questions and get the answers recorded. Third, and when I say recorded, make sure they're written down, make sure there is a whole reporting process in place. So it's all about gathering facts and information. That's what's happening now. Third, interview all witnesses and third parties. Phrase the question so you don't give any information or influence the responses. For instance, it's better to ask, have you heard anyone say something to or about Karen that made her uncomfortable? Rather than, did you hear Steve proposition or threaten Karen? So it's really about how you frame the questions, which should kind of not be leading questions, if you will, but the job is to get that information in an objective manner and not to sway the person you're asking. So it's important to get the questions down in writing, review them, make sure they're being phrased in a professional and objective manner. It's all about planning and making sure every question is asked just in the right manner. So let's continue on. The next step is to weigh all the evidence and the credibility of each party Is there any possibility the complaining employee is trying to make up for a poor performance review or a disciplinary action? Are there any previous complaints against the alleged harasser? Once all of the evidence is in, interviews are finalized, and credibility issues are resolved, a determination should be made as to whether the actual harassment occurred. That determination could be made by the investigator or by an HR or a management official who reviews the investigator's report. The parties should be informed of the determination. So it's a very serious matter, an accusation of sexual harassment, as is the investigation with all the steps that we just reviewed, which must be done fairly and objectively. So there's a lot to do here. So let's continue on. Finally, number 6, we're talking about taking an action. If it's determined that harassment did occur, the employer must act promptly to address it. An employer should make clear that it will undertake immediate and appropriate corrective action, including discipline, whenever it determines that harassment has occurred in violation of the employer's policy. Both parties should be informed of these measures, and we'll discuss corrective actions in more detail in a moment. So let's continue on. It's important to make a detailed record of the investigation in writing. If a formal charge of harassment is filed, these detailed notes should be critical to the company's defense. The record should be sufficiently clear and detailed so that anyone in the company can understand and use the information. Among the documents that an employer should gather and keep are initial complaints, including any complaint forms, witness reports, written materials relevant to the investigation, including emails, notes, or files, records of meetings or interviews with the parties at issue, discipline or termination reports, and notes of supervisors or other management personnel involved. The company's investigation protocol should specify the amount of time that documentation gathered during the investigation should be retained. Keep in mind that in the event of a charge, if it's filed with a government agency, personnel or employment records relating to the issues under investigation because of the charge must be kept until the final disposition of the charge or any lawsuit based on the charge. Again, as with all parts of your organization's sexual harassment policy, make sure that your investigation procedures comply with all state law requirements. So you can see there are a lot of different areas related to this that really have to be put together in a cohesive plan. This is not a small matter. It's very serious. Both the complaint is, as well as the entire investigation. And so it's important to have all of this prepared, developed, and all worked out in advance. So now we're going to go on to the next slide because we're going to talk about taking corrective action. Now, what do we mean here? Remedial measures should be designed to stop the harassment, correct its effect on the employees, and ensure that the harassment does not occur. These remedial measures need not be those that the complainant requests or prefers as long as they are effective. However, remedial measures should not adversely affect the complainant. For example, if the parties must be separated, the harasser should be transferred unless the complainant prefers otherwise. Remedial measures that penalize the complainant, again, as we talked about before, could constitute unlawful retaliation. So it's very, very important to remember that when taking the corrective action. So let's go on because we're to the next slide. We're going to talk more about corrective action and examples here. So in determining disciplining measures, it's important to understand that the employer could be found liable if the harassment does not stop. At the same time, overly punitive measures may subject an employer to claims such as wrongful discharge and may simply be inappropriate. Now, to balance these competing concerns, disciplinary measures should be proportional to the seriousness of the offense, right? It makes sense. If the harassment was minor, such as a small number of off-color remarks by an individual with no prior history of similar misconduct, then counseling and an oral warning might be all that is necessary. On the other hand, if the harassment was severe or persistent, then suspension or discharge may be appropriate. Now, it's important to remember, remedial measures must both stop the harassment and ensure that it does not reoccur. Such measures might include an oral or written warning or reprimand, transfer or reassignment, demotion, reduction of wages, suspension, discharge, training, or counseling of the harasser to ensure that he or she understands why his or her conduct violated the employer's anti-harassment policy, and monitoring of the harasser to ensure that the harassment stops. So you do have a range here. And again, like all of the planning that went into and documenting that went into the investigation, the same thing has to go into what corrective measures must be taken. And let me just say at this point, if you're not sure, you're it's a toss-up for you, let's say, between demotion or reduction of wages or discharge versus suspension. Our advice would be contact a person, an attorney, expert in labor law, or HR professional who has absolute experience in being able to give guidance in this area. If you're not sure, that is the best way to, as far as next steps, to make sure that you're doing the right thing. If you feel it's just something that you can't handle internally, you then seek the guidance of a professional. So let's continue on. More about corrective actions. Remedial measures also could correct the effects of the harassment. Such measures should be designed to put the employee in the position he or she would have been in had the misconduct not occurred. I'm going to give you some examples now. Restoration of leave taken because of the harassment. Expungement of negative evaluations in the complainant's personnel file that arose from the harassment. In other words, if there was some quid pro quo sexual harassment going on where somebody didn't do what was asked of them and then got a bad review, well, we know that that has to be changed. That review has to be absolutely taken out of the personnel file for that employee. Reinstatement, an apology to the harasser, monitoring treatment of the complainant to ensure that he or she is not subjected to retaliation by the harasser or others in the workplace because of the complaint, and the correction of any other harm caused by the harassment, such as compensation for losses. Again, make sure to comply with any state law requirements. So as you can see here, there is so much going on in terms of choices, and you really have to, again, evaluate and understand exactly what's going on. Keep in mind the federal and state laws, and again, seek counsel, seek the guidance of an expert if you're not sure you've covered everything you needed to cover, but at least you know here are some of the options, and then, of course, there's a lot of thought and analysis that must go into it before the corrective action is taken. So now we're going to talk about, in our next slide, preventing sexual harassment. Now, obviously, the best solution to the problem of sexual harassment is to prevent it in the first place. Like, we all feel that way. It's worth repeating that to help prevent sexual harassment, organizations should clearly communicate to their employees that sexual harassment in any form will not be tolerated, and respond immediately when a claim of sexual harassment is made. In addition, prevention efforts will likely be much more successful if every employee in the workplace is given training in how to recognize, report, and prevent sexual harassment. There is really no replacement for training. One way or the other, every employee should be trained on how to, as we said, recognize, report, and prevent sexual harassment. And as we said earlier, a few states require such training for certain employees, so it's always important to review your state requirements. And so let's continue on. Now, as a manager or business owner, you can help prevent sexual harassment in the workplace by modeling appropriate behavior. So important. Use your best judgment, and when in doubt, err on the side of caution. Also, let your employees know if their behavior seems inappropriate. It's something that you certainly want to know about. And again, setting that example, it goes back to kind of what I said, earlier on in the presentation about respect, professionalism, kindness, all of those aspects of just human behavior. If those are modeled all the way from the top down, from the highest level owner down to managers, supervisors for all employees, it makes such a difference. Remember that what may be considered appropriate or acceptable behavior by some may cause offense or distress to others. It's important to remember that from an objective standpoint, and it's hard to maintain objectivity because we all have a lens that we look at things through. But it's important to think about the sensitivities of all employees. Do not encourage or permit offensive jokes or stories in the workplace. Instead, tell them their behavior is offensive and should stop. This may not always be an easy task, but it is one that will set the tone and possibly avert situations rising to the level of harassment. So it's important to think about what I just said, because once a certain philosophy and a certain standard is set, and it's a good high standard, that's going to make such a difference across the entire company. Really, it's important to think about that. So let's go on to the next slide for a moment. It's also important to actually talk about the concept of staying informed. The workplace and the legal landscape are always changing. So stay current with your training and commit to employing best practices as you work to prevent, recognize, and remedy all forms of harassment. If the situation is confusing or seems borderline, or if you need clarity in any way, engage an HR professional for assistance, or, like I said, seek guidance by a professional, either a labor law attorney or an expert in this area. Again, remember, there's so many moving parts here, so many different requirements, both from the law itself, federal and state, behaviors that may not exactly fall into sexual harassment, the whole investigation process. There's a lot going on here, standards that you want all employees to meet or even exceed. It's a big job, but if you're committed to it and you believe in it, you will have an excellent workplace where sexual harassment doesn't exist. And you've done a great job in helping to prevent it. So just closing up right now, I want to thank everybody for joining us today. And please stay tuned for new webinars. They're coming. I'm just going to take one or two quick questions. I see them coming in right now because we've had a long session together. So question number one is, and we did cover it a bit, can I compliment a person at work on his or her appearance? And the answer would be yes. Simply complimenting someone or making an isolated remark about his or her appearance is not considered harassment, but the person must be careful. If the same remarks are repeated day after day or become more suggestive, they might rise to the level of harassment. The speaker's gestures or tone of voice also might make a difference as well. So it's important to remember this, that even something that may sound or start off innocent may not eventually, and may rise to harassment. And one final question I'll take right here is, how can harassment not involving sexual activity or sexual language be sexual harassment? So the answer, we covered it a bit in the presentation. Offensive remarks about a person's gender, like making offensive comments about women in general, is considered sexual harassment. And I would say, just as a final answer, if there's even a vague innuendo or doubt, or there might be some element of that particular remark that could be construed as offensive, don't say it. Don't say it. Stay within the professional guidelines that every workplace should adhere to, and you can never go wrong. Remember, it's important to learn all of this and make sure it's implemented throughout your organization. Thank you very much, folks. Look forward to the next webinar we'll be doing next month. So again, thanks very much, and we will send you out a copy of the presentation.